Our then resolution process in a major bad loan case has been halted by the National Company Law Appellate Tribunal. The NCLAT has ordered a status quo on the insolvency process of Electrosteel Steels. Now, this move comes after a petition is filed by one of the losing bidders in the case, Renaissance. Ashmit Kumar is here with more details. Ashmit, what is Renaissance contention, and take us through the order that the tribunal has given?
Well, a setback coming in for the insolvency proceedings for Electrosteel Steels. What we understand is that the NCLAT has passed very clear orders directing a status quo to be maintained with respect to those very same insolvency proceedings. Not just that, the NCLAT has gone a step further and directed for the panel that is in charge of management of the company to restrict their expenses to only the day-to-day expenses of the company, so further being limited the scope and the operation of that panel as far as Electrosteel Steels is concerned. Now, both these orders come on the back of an appeal that had been filed by Renaissance Steel. Renaissance Steel, mind you, is one of the bidders in contention as far as Electrosteel Steels is concerned. And the reason that they've moved NCLAT is to challenge the eligibility of Vedanta under Section 29A. Now, on the back of that, what we understand is that the NCLAT has agreed to hear Renaissance Steel's application, has also issued a notice to Vedanta, and it has done so because Renaissance Steel essentially argued that their bid was to the tune of 6,000 crore rupees, which is 700 crores more than Vedanta's bid of 5,300 crore rupees. So that's the moot point here, Section 29A, the difference in bids. The NCLAT will now take up this plea for further consideration on 17th of May. Back to you.
Okay, Ashmit, let's also talk about the other story that you have been tracking. Slew of telecom reforms, including flights, getting the internet accessibility as well.
Well, two big takeaways as far as today's Telecom Commission meeting is concerned. The first is that the next time you fly, 3 to 4 months later in an airline, you will be able to access the internet. You will be able to make calls just as you're able to make calls here when you're on the ground. That's the broad takeaway. The Telecom Commission has approved the TRAI's recommendations. The recommendations were to the effect of allowing for in-flight mechanism for accessing the internet as well as for making calls. To develop this entire mechanism, a new licensee class will have to be developed. Framing of that licensee framework will take about 3 to 4 months. So that's the time essentially that you're looking at, and about 3 to 4 months later, the OT sources confirm that they are optimistic that internet can be accessed, calls can be made via flights. This will be, of course, applicable to both domestic as well as international airlines. As far as Indian airspace is concerned, of course, the airlines on their part will have to coordinate with the telcos. That's part one. The second takeaway is with respect to grievance redressal mechanism. DOT sources confirm that they receive as many as 10 million complaints every quarter, and to address that, a new mechanism will now be developed. The first complaint will be lodged with the telecom service provider. The second will be an appellate tribunal that again will have to be created by the telecom service provider. The third layer would be an ombudsman. This is a first as far as the telecom space is concerned. The ombudsman will have to be created by the TRAI. The ombudsman can be per telecom service provider or for certain geographies. That's a call that the TRAI will have to make. But nonetheless, as far as grievance redressals are concerned, an ombudsman will come into being. TRAI will take charge. So clearly, two big takeaways from today's Telecom Commission meeting. Back to you.
Okay, thank you.